And please bless the Cherokee people as we go through our daily activities and our future. And please look over us during this coming weekend, the Cherokee National Holiday, in which we celebrate you, Lord, and the history of our people, and the progress that we've made, and the future that we're going to go forward with. And please look over the counselors here and give them the guidance to act in the best interest of the Cherokee people and to do your will. In the name of the Father, Son, Holy Spirit. Amen.
Roll call. Meredith Bailey. Here. Bill Anglin.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Bozer.
Here.
Julia Coates. Fred McCall. Joe Crittenden.
Here.
Jody Fisher-Hop. Here. Janelle Fulbright. Here. Don Garvin. Chuck Hoskins Jr.
Here.
Tyler Glory Jordan. Present. Curtis Snell.
Here.
Chris Soap.
Here.
David Thornton.
Present.
Kara Kellen Watts. We do have a quorum.
Next order of business, approval of the July 31st regular session minutes.
So moved. Second.
Moved in second. Any discussion on the July 31st minutes as written? All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carries. And the approval of the minutes of the August 11th subcommittee.
Move to be approved.
The motion, the second.
Second.
Moved in second. Any discussion? All in favor, signify by saying aye.
Aye.
All opposed, same sign. July 31st, August 11th minutes stand written, stand approved as written. Next on the agenda are reports. Ms. Wright with the Marshal Service. Good afternoon, Sharon.
Good afternoon. How are you? Are they keeping you guys busy with the retreat and all that's going on? I got my report to you about mid-morning. I don't know if you had a chance to go through it with everything that you've been doing. It's there for your perusal. We have had people up at the Standing Rock, and I think all of them but one is back, and he'll be back at the end of this week. They've been very appreciative of the help that we've lent up there with the public safety issues. And one of the things I'd like to brag on is, you know, here we try to do community-oriented stuff, and we'll take things out in our patrol cars and give out for packages and things. They were not doing that up there. They were just seeing how many arrests and different things, and they sort of made fun of my last two officers because they had elder packages and they had children's packages and they were like, we don't do that touchy-feely kind of thing. They brought in some great information for some really warrants with some teeth of drug dealers, and they started asking for incentives from their own areas to be brought in so that they could do some of the same things our guys were doing. So it really does work in the end to get some of that stuff out there and then build a rapport. So we're real proud of them. We've been pretty busy with cases, and if you'll notice, several of our cases are child sexual abuse. There's a conference in September that the U.S. Attorneys is a part of, and they invited Shannon Buell, who is one of our investigators. He's had several very good cases in the federal court system, and he's going to be speaking at their conference in conjunction with one of their U.S. attorneys on Indian country cases of child sexual abuse.
When is that?
I'll have to get the dates. I know it's in September, but I'll email you the dates on that, and if I can find the brochure, I'll even send it over.
Anybody else, Sharon?
Unless you have questions.
Oh, I'm sorry.
I'll defer to Harley. I bet he's going to ask the same question I am.
Mr. Buzzard?
Sharon, can you go over real quick the list of counties that we have cross-jeopardization with and what we don't?
Might be easier to tell you the three we don't.
Okay, that'd be fine.
Tulsa, Washington, and I believe Ottawa. Even though we have a cross-step with the VA that's in the Ottawa, has that under his jurisdiction, we don't have one with Ottawa County. Those are the three we don't. We've got one with every other, McIntosh, we've never had one with, and we have one with them now, and Wagner was another area we never could get one, and we have one with them now, but those are the three we do not.
Thank you.
Dr. Cobb?
We do have cross-step possession with Ramona, though.
Yes, we do.
Can you tell me, just kind of walk me through, I'm asking for my own information, in Delaware County, when the UKB officers were involved in that, how did that end up in there?
And I think he put that in the summary, and I went ahead and put it in. We were not notified of the crime. Delaware County was, and UKB somehow, because they had officers that patrol up in the Kenwood area for whatever reason, showed up on that call. They heard it on the radio. They showed up on the call. They got there prior to the Delaware County officer. They both took information, and I guess one assumed the other one would write the report. And if you'll notice, it came about later. So when I think it was the victim, then wanted to see where that case was, and Delaware County was saying, well, we've got this amount, but I think UKB worked it, but it's Indian country. So when we got involved, we were trying to get that information, and that's how we knew UKB was involved. We never went back to them to try to see what they've done, although Delaware County did. But in the end, after all of that, it ended up being on fee land. So but they did ask us to participate in that and help them with that. So we went ahead and progressed, but it is a Delaware County case. But they had turned it, somehow the victim thought that they had told her it was Indian country.
Let me be clear here that UKB and Delaware County, for some reason, didn't communicate with each other. Is that correct?
Correct. They were both at the scene, but they never coordinated the information after the incident happened.
Appreciate it.
Any other questions, comments? If not, thanks, Sharon.
Have a good holiday.
Thank you.
Have a safe one.
Next report is Ms. Hammond's Justice Department.
Good afternoon, Madam Speaker, Council, hello. I'd like to, if I might, formally introduce to the committee two of our new attorneys. They're here with me today, Elizabeth Odell and Brandy Inman. They started August 11th. They can tell you where they're from. Brandy is waiting on bar results. She just graduated from TU 2 weeks, September what? September 12th. Okay. Elizabeth, you want to tell them who your family is, where you're from?
I'm Elizabeth Odell, formerly my name is Elizabeth Wilson. I'm from Tahlequah, and I now live in Culver.
I'm Brandy Inman. So I'm enrolled under the name Baldwin, and I live in Tulsa right now. Always lived in Tulsa.
Ms. Fishing-Hawk, did you have a question?
Yeah, I was wanting to know, two questions. Are you all Cherokee, and do you all have a license to practice alcohol?
Well, I'm waiting on my bar results.
After September 11th, she should.
Yeah.
Your stomach churning?
Yes, it is churning. Thank you, guys.
Mr. Baker?
And TU has a 97% pass rate. So I assume you're not in the bottom three.
I would hope not.
Was that pressure or what?
Just a little.
Any other questions of the two officers, attorneys? Yes, go ahead, Diane.
Thank you. And we have one more that will be starting September 8th, and I'll bring her to introduce to you also, and she's also Cherokee. I always used to brag that our department was 100% Cherokee. We no longer are. We have one attorney who is Mississippi Choctaw, but she's married to a Cherokee and she has Cherokee children, so we are darn near. That's close. I will just hit a few of the highlights. We've been busy this last month. Sarah Hill has attended the Tribal Water Summit. Of course, Becky Johnson has been working on the sex offender registration diligently. Our business from the Housing Authority is booming, I'm sorry to say, with a lot of foreclosures. Those are not instituted by us, but we are named because we have a second mortgage, or we're named as a creditor in a bankruptcy. Sarah's also been a speaker for the Oklahoma Independent Living Foster Care Program. I attended Oklahoma Bar Association Leadership Academy last week. And those are some of the highlights. I'd be happy to answer any questions that you may have.
Ms. Jordan and then Mr. Buzzer.
Were any of those first mortgage foreclosures? All second? And
I think that's that correct.
15,000?
Yes. Okay. That purchase price second.
Mr. Buzzer?
And Diane, those foreclosures, what types of loans were they? Were they Title VI, MAP loans, or?
I think most of them have been MAP loans.
Exactly.
I'd have to double check all those to give to you. I'm pretty sure they're MAP loans.
Okay. Thank you.
Any other questions?
Actually, the Title VI would always be a first mortgage. Those maps are always going to be second.
Right.
But that's up to $15,000 too.
The other one more. Could you furnish or have housing or someone furnish? That would be information I'd like to have. Is which particular one was it? Was it the MAP program or Title VI? Because there's a little bit of difference in those two programs. Or quite a bit of difference, actually.
I will.
Okay, you think they're all MAP?
I think so.
Okay.
Diane, are you at a point where you can comment on the email that I received from the UKB Health Director, I think is his title?
Just summarily, I will get out a response to your email hopefully this afternoon. I was working on it and just didn't get it finalized before rules today. I pulled the regulations cited by Mr. A, CFR, and 638, the self-governance reg. I feel pretty confident in assuring you that UKB's consultation or consent is not required to compact with IHS under the new funding agreement. Certainly IHS doesn't think so. I don't think so. I think that IHS's interpretation of the service area and the jurisdictional area is in line with that of HUD and the other federal agencies and federal decisions that have held, because UKB does not have a former reservation area. This is our area that their consultation nor consent is required. And that's basically what my letter will say, but it will be in more detail.
Okay. Any other questions?
And one thing I would want to add is, to dispel any ideas that councilors may have. Any vote that you take is you're acting in your official scope. No one would have, let's say worst case scenario that they file a lawsuit. They wouldn't be able to file against you individually. It would be acting within your official capacity, and as we all know, anyone with a filing fee can file a lawsuit. So I want to assure you of those concerns.
Absolutely. I mean, for an action like that, it would be in your capacity as a tribal council member, so of course the nation would represent you, because it's really against the nation itself. So I've got your back. I think I told one of you at one point.
Any other questions? Ms. Fishinghawk?
Yeah, can you get a list of where them foreclosures were?
Sure.
Anything else? Ms. Jordan?
Is there a way that you can get us a list of those? I'm assuming that you probably looked over the loans that are being written off. Well, you remember last month we appropriated a certain amount of money for bad debt write-off, and I would assume that went through your office for approval after you looked to see whether there could be any further collection work.
I don't think so.
It didn't go through your office for
I don't think
collection
so.
efforts?
I don't think so. And I don't know.
Do you
We
know
probably
whether-
need to talk in detail more with Anna I thought that what she explained to me, that that line item was for future contingencies. But we haven't reviewed any notes and said these are not collectible, write them off. We haven't done that. We try to squeeze the blood out of the turnip.
Well, and is that normally the policy that it would come through your office? If it's going to be written off, prior to being written off, would you look at it?
I don't know the answer to that. I don't know if that's the policy over there or not. Certainly anything that they want collected on comes to us, but it's possible that they could make a decision without it going through my office.
Well, would you agree that we probably need to look at it to see if there's any collectability there?
I would like to.
Okay.
That would be my choice.
Anything else, Ms. Jordan? Questions, comments, Ms. Hyman? Thank you very much.
Thank you.
Anyone here from the Election Commission? Tax Commission, Sharon Swepson.
Afternoon. I think you have my report, and I'll try to address any questions you might have on that. I would like to make a note that we have been open for the past month on Tuesdays and Thursdays, extended business hours till 6 at the Tahlequah office. I think the maximum that we've had is like 5. The average is about 2, but the word's getting out. I know that it's been on the radio. They've got it out in the newspapers and things like that, but I think word of mouth is probably the best way to get the message out there that we're open till 6 o'clock. So.
Now, I've taken advantage of that. Mr. Baker?
Where are smoke shops?
As far as the tobacco compact,
Yeah.
we are negotiating a tobacco compact right now. We have been in contact with the state office, with the governor, and with Meacham. We have sent them a couple of drafts. They sent us back one this week. We're reviewing it right now, and it's kind of a back and forth deal right now. It's going through. We're working with Diane's office on that also, but hopefully we're hoping that we will have something real soon on that, and a rate for everyone, a new rate, new compact.
I can assure you that the smoke shops, need some relief, and anything would be relief.
I know, and I talk to most of them on a daily basis, so trying to keep them updated also.
Is there a cutoff date?
Yeah. When does the compact with the other tribes that's sort of controlling this, is there a date that's a little precarious that we need to be concerned about?
Most of the new compacts that have been signed within the last month, and they just signed another one a week ago Friday, I believe, and it was the Otoe, Missouri, and it's basically the same compact as what the Comanches and the Kaws had. So, and that rate is $6.65 is what that rate is in those compacts for their full rate shops, is $6.65. The Kaws does have a border rate in it, $2.58, but all of their stores are tribally owned and they are border stores.
And our people are paying what today?
Right now, if they're a full rate shop, they're paying $8.58, and of course then we had a 50-cent tribal tax, which has been waived temporarily. So the $6.65 would be a rate for them.
Yeah. And that $6.65 would, right now is how much to the state and how much?
$5.15 to the state, $1.50 to the tribes. That's the way it's written right now. That's what the Comanches reads. That's how the Kaws reads. That's how the Otoe, Missouris read. That's the standard right now of what's being signed.
Is there a clause in it that we can't lower ours?
The $1.50, it does say that is a minimum on the tribal side.
All right. Thank you.
You said something to the effect of a rate for everyone. Does that mean that there's no, in the draft you've seen, there's no border rate?
There is a border rate in the Kaws, and I haven't seen the Otoe, Missouris, but there is a border rate in the Kaw, and it's $2.58.
And can you say whether the drafts that are going back and forth?
Our drafts do have a border rate in them. I'll try to explain, Diane, maybe better explain it tonight. It has a border rate in it, but the way we've worded it on the tribal side is the way we talked to our shops and met with them, everybody wants to be the same across the board, and we're working with the Osages and the Creeks. So the way it would be with everybody would be at $665, all the shops. So it'd be a flat rate.
Will you finish, Mr. Ross?
Different topics, so we yield to Mr. Ford.
In the new draft is the most favorable clause in that new draft.
Yeah.
Mr. Austin?
On car tags, were you able to research the state of Oklahoma's new tagging of those, I can't even think of the right word for it.
Utility vehicles.
Utility vehicles.
Yes, and we have legislation drafted for our commission that meets on September the 10th, and they will review that, and if they approve that, then we will move it forward to this body.
And do we have any discounted rate for active military? I know we have a veterans.
No, not for the active.
It's my understanding the state of Oklahoma, though, has some sort of discount for active military. Are you familiar with that?
I'm not, but I can research it and find out.
If that's the case, and just at, doesn't have to be the next meeting, but is there well, there may not be a quick way to evaluate. I just wonder what the significant economic impact would be if we were to adopt that. I mean, it seems to me we ought to be meeting or beating Oklahoma on
I
how
can
we treat
research it
our...
and find out and try to get some information for you on that.
Dr. Cobb?
Looking at your graphs,
Yeah.
what happened to the boats? They're significantly down over the course of 07 to 08. Went down 33%
On the boats,
down the boats.
for the month of, most of your boats, if you look at the year-to-date or the monthly?
I'm actually looking at both. It went down to 15 here,
Right.
33 there.
This is because most of your boats come due in the month of June.
Right.
And this would probably have some significance on the fact that some of them are going to the 3-year tag,
Gotcha. That's my question.
so they don't have to renew every year.
That's what I wanted to know. Thank you.
Have you thought any more about the farm tag limit?
Yes, we're researching that also, and it will be a point to the commission.
Okay. And then if you make a change, will it come back to this body?
Yes. Anything that changes in our law will have to come back to this body.
I don't think it'll make that much difference except to a few of the larger farming operations, but that limit is really...
The thing that we have to be real careful about is, and the reason that was limited is because there is a lot of abuse. You would be surprised at the number of people that have some uncle or aunt on their title so that they can get a farm tag. But if that's the way the title comes in, there's not anything that I can do about that. But it does lead to abuse because that they think if I could put my aunt or uncle on there and I can get a $25, $30 tag, then they save a chunk of money on that. So that's things that we just have to be careful
I
of.
might want to point out to the aunt and uncle that's extreme
fraud.
liability. Well, it's fraud, but it's also extreme liability on their part.
Yes, it is.
In the event of a lawsuit.
It is, and it has to do with their insurance too, and I try to point that out to them also.
If we could consider it, though, for the legitimate farming operations, because what's happening is they're having to go back to the state because of the limitation, and most every farm now is going to have more than our limit.
Right. It will be an agenda item. Our agenda will be posted tomorrow, and it'll be an agenda item for the commission.
Thank you, Sharon.
Mr. Beasley?
And then just to follow up on Councilor Glory, Sharon, is there a limitation on the commercial side?
I truly can't answer that off the top of my head. I would have to check and see on the commercial
Several
vehicles.
commercial operations that have dump trucks, semi-trailers, tractors, and stuff like that.
I really don't think there is, but I will check and see.
Okay, I'd like to check that. Thank you.
Other questions? Mr. Baker?
What is the limitation you're talking about?
For
vehicles?
5, isn't it?
Is it 5?
I think it's 5 that you can tag on your farm card. For that citizen, you can have 5 farm tags.
Gotcha.
And the reason it came up was we have several out north of town, farming operations that, they've got these little utility vehicles they're tagging, they've got the ton trucks that pull their trailers are tagging, and they're having to go back to the state because it's unlimited with the state and there's a limit with us. I just hated to see us lose our Cherokee people that way.
Any other questions? Thank you. Ms. Hanby, self-governance?
Good afternoon.
afternoon. You have my report. We have been short-staffed for some time, and as you all are aware that Tom Elkins had been detailed to environmental back in December, and he officially took that position. And we've also had several people out on medical leave, so we're really short-staffed in self-governance. But we are continuing on with some work we have going. Just a brief update to let you know all of the certifications have been signed on the IHS funding agreement, and it's on the director's desk for signature as of this morning. And I'm sure that we'll have some more updates for you today at 5 o'clock. Now we're starting to work on the DOI funding agreement. We have what's known as a reprogramming request, where we go over all of the money again and sign off on that and look at some footnotes and things like that on this would be the second year of a 3-year agreement. So I'll be working on that in the next few weeks so that we'll have that ready October 1. I've also been selected to participate on the labor force report work group, and so I've been participating in primarily through conference calls instead of traveling. We've stayed pretty close to home with working on some other issues with Hastings and so forth. So I've been participating on that in conference calls, but I'll answer any questions you may have.
Questions from Ms. Handy?
Okay.
Mr. Buzzard?
I've got a couple of questions. Vicki, on your DOI reprogramming notices, is Rhodes involved with that, or did we do a 3-year contract on that before?
Well, of course, Rhodes is part of the DOI, but it is listed on there. They've gone to a new system about, what's it been, about 2 years ago, I guess. And it used to be that we could go online and I could input the stuff and then it would go through for their approval. With some of the security clearances and the new system, we're trying to get that set up to where I can do that again. But right now we're having to coordinate with Ken Reinfeld in the DC office, and only he can actually input the stuff, but it will have an estimate of what the roads funds will be based on prior years. Yeah.
The other question, who does our labor force reporting here? Do you do it out of your office, or?
Out of our office.
Okay.
We coordinate that with other groups such as registration, the GIS department, and others, because we have to gather all of that data to put in the report. And
when will that report be done?
well, that's a good question. One of the problems with the labor force report is it's nationwide. It's self-reporting. So the tribes put the data in, and for the self-governance tribes, we have a coordinated effort with that. Some of the non-compacted tribes, it's a little bit different. The last one that's actually been issued officially was in 2003. Tribes have been submitting information, but there hasn't been one released, an official labor force report, since '03.
So the, I guess you call them the direct service tribes is the ones that probably don't do their own reporting, and BIA actually does that yet.
Well, I think there's supposed to be a coordinated effort in doing that.
Well, I'm sure they would have to be.
And that's one of the things that this work group is looking at, is trying to streamline that and look at that old reporting format and looking to see, one of the questions that I had when I was selected to be on the work group is, number one, where does this information go and who's using it and for what purpose, so that you know that you're gathering the correct data. And it was interesting to me that all the various answers you got, and even the officials that couldn't really tell you where it went. who was using it. But anyway, that's part of what we're looking at is, are we gathering the correct information on there? And how is a better coordinated effort in doing that? And I think there should be better coordination with there was a national work group for data management for all the tribes, and that group ran into some problems. For one, there's been, over the last few years, as you all are aware, there's been a lot of turnover with DOI officials. So about the time they get something going, they've got someone new to deal with. And so it's been a very slow, and I say, even for the department, it's been a slower process than what we would like to see.
Well, I knew on some of those work groups that you participated in, they were wanting to use the labor force reporting on that. I don't know if that ever happened, but if you don't have the right data and if they use it, then you're going to get short on funds. That's what
That's right.
Okay, well, I'll check back with you later to see what's happening. Thank you.
Because if they use that, it would have a direct impact on our funding. So,
All right, thank you.
Thank you, Sandy. Mr. Hunter?
Mayor comment.
Please.
I quoted a while ago that TU had 97% pass rate. What I failed to mention is that it's because of Elizabeth. They brought her in to bring up the pass rate. Is that not true?
That's correct.
And you brought it from quite several points?
It was a 69%, we brought it up to 93%.
Yeah. And so anyway, I read that and it just dawned on me who she was, really. So, all right. I'll shut up.
Mr. Hummingbird? Gaming Commission.
Good afternoon, Madam Speaker, council members. I believe you have a rather abbreviated report for me in your packet this month. Be happy to address any questions there. But I do have one follow-up issue that I'd like to bring to the committee's attention. That's follow-up to Councilmember Buzzard's question last month about the BIA and NIGC quandary over land determinations and the ability of the NIGC to make such determinations. In meeting with the NIGC a couple of weeks ago, I asked them that very question, and it is their belief, the chairman, the Office of General Counsel and Chief of Staff, that the Indian Game and Regulatory Act does bestow that ability upon the chairman to make certain determinations as far as gaming is concerned. The BIA still contends that they have the, of course, land into trust determinations. There are some additional changes going on to the Section 20 regulations now as we speak. And the NIGC has sent out a letter as of a couple of weeks ago requesting input from tribes on whether or not they should adopt their own determination standards or not. The original comment deadline for that was set for September 5th. I believe they have extended that timeline to September 30. So we're going to be taking a look at those proposed regulations and see what kind of comments, if any, we may need to make.
Yeah, and that just, Jamie, that just goes to show the people that are taking away the sovereign immunity of the tribes when they try to do that and leave that up to the gaming regulations to make that determination. The other thing, and maybe you were going to comment about the, I don't know if you can comment about the lawsuits that's going on with C&E with the one person up there now or not, but those are some more things that's being chipped away for sovereignty issues where those are going to be held in court. So, anyway, that's a concern. I think we all need to be aware of what the NIGC is doing and what they're trying to get done. So,
Yeah.
thank you for bringing up the data.
We try to keep a close eye on NIGC because there are times that they do try to chip away at the tribal's overall sovereignty as well as the duties and functions of the tribal gaming commissions through some of the regulations that they want to adopt. And whenever those do come down the pipe, tribes have voiced their concern readily and loudly. So we continue to keep an eye on the NIGC.
Thank you.
Dr. Hogg?
I gave up a long time ago trying to calculate all these fees. I'm going to let y'all much smarter than I am, but kind of enlighten me. Why are these compact fees, why are they just all over the board? And I'm looking at state fair meadows, horse racing. They're just, from year to year, they're just, what really drives that?
Well, the easiest one to tackle first is Fair Meadows. the way the compact was situated, the horse track in Tulsa, instead of having machines located at their facility, there was an annual fee or a monthly fee that's paid to the track by the 3 tribes in the area, Cherokees, Chickasaws, and Osages. The proportion that any one tribe pays is commensurate with however many machines that they have at their location. So if the Cherokee Nation made up 75% of the total machines, the compact machines in that area, our portion of the payment would be 75%. And as that number goes up and down, so does the payments to Fair Meadows. So as the Osages and Creeks add to or take away from their compact machines, so does our payments to them fluctuate. Correct. For the compact machines and for the OHRC, the only best estimate there is in 2005 and in 2006. You will see a big jump between 5 and 6. Well, in 2006, when we first started getting some of the actual compact games in, 2006, 2007, you saw a proliferation, a huge increase of compact machines at our facilities versus the year before. In fact, we do a trend analysis for our commission that I can share with you, and what we show them is how many compact machines we have month to month to kind of get an idea of where and how these fees are calculated. Because right now, in 2006, I can roughly say that the compact machines roughly made up 30 to 35% of our floor. In 2007 is our largest concentration, and now we are looking at 60% compact machines versus 40% Class 2 machines. And 2008 is just simply only halfway through, but you can tell it's on pace to meet the 2007 numbers, if not surpass those.
That answers my question. Okay, thank you. Appreciate it.
Any questions, comments? Brief report. Thank you, Mr. Hummingbird.
You're welcome. Thank you very much.
Mr. Henry, codification.
Yes, the codification process continues a bit slowly than the last few months. We are attempting to have another codification meeting on Friday, September 6th, I believe, at 2 o'clock, and we will continue on with the process, but we're getting there.
Questions for Mr. Henry? Thank you. Diane, did you have anything to report on GBG?
The only thing new is I know that the FBI and the marshal that's assigned to the case continue their work, and I know that they've conducted some interviews during this past month because they apprised me of those, so it is still alive.
Okay, thank you. Anybody have any questions? It's not.
Sorry.
Next order of business is old business. Just items 1 and 2 are the criminal code. Ms. Jordan, would you tell me where we are on those?
We have some questions that we want to pose to the body, which will be under new business, that will help us better, will give us more guidance on how we continue our work group. So I would ask that under the old business that the 2 be tabled until next month, and possibly we'll be able to come back to you at that time with a finished product to present.
Have a motion to table and a second. All in favor, signify by saying aye. Aye. All opposed, same sign.
No.
1. Sure.
I'd like to make a motion too that the act that was passed to full council also be included on next month's rules agenda and brought back, that there's some amendments that we'd like to propose to it.
Which one?
The actual act dealing with Adam Walsh Act that was being tabled for the past 2 months at full council.
You want that included on the rules agenda?
Yeah,
for-
so it would be all 3 acts at once.
Do I have a second?
Second.
Moved and second. Any discussion on including the Adams Walsh legislation on the next rules agenda for, what is this, August? September? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Okay, item 3 is the elected officials' compensation. Mr. Garvin?
Thank you, Madam Speaker. We're not quite ready to proceed. I make a motion to table this to the September meeting.
Second. Moved in second. All in favor, signify by saying aye. Aye. All opposed, same sign. Will be tabled. Under new business, number 1 is the determination of guidance questions concerning the sex offender registration, sentencing, and sex contact. Start the discussion on that.
Yes, ma'am. We're going to pass out questions that the work committee or working group formulated. We came to a point in the legislation that we were going to need some important questions answered by the full committee before going forward. And the idea being this: once we get these questions debated and answered here today, the guidance from the Rules Committee, we will then amend the legislation appropriately and then bring forward to full council in the September rules for either passage or, to deliberate one way or the other on that. If it then passes full committee at September rules, it will then be considered at the October full council meeting, which meets the deadlines that we have previously discussed.
Is this the same as in the book as what you passed out?
Should be. Okay. Now, and if I could have Becky up here to join me, and the members of the work group that are here, correct me if I'm misspeak. One major question that needs to be decided in several parts of the legislation is whether a deferred sentence can be offered to a criminal defendant. Just a brief background: there are two types of to a sex offender, sex offender offense. And in the list of questions, there's a litany of crimes that it would apply to. Now, just to state briefly, there are 3 ways a person can be sentenced in a conviction to a criminal act. Okay, if you're found guilty, you can be sentenced to prison. Okay, and you go to prison, you serve your time, etc. And or sentence, prison, and a part of being the remainder being probation. Another way of sentencing a person is for them to receive a suspended sentence, which says we're going to sentence you to prison, but we're going to suspend that or not put you in prison, and you are going to follow these rules and conditions of probation during that sentence. That is a conviction, and you will always have a conviction on your record. A third option is called a deferred sentence, wherein a person pleads guilty or no contest, but the court does not accept that plea and defers sentencing for a period of time. And if that individual does what is required by the court, i.e., these classes, probations, do not violate any state, federal, or tribal law, then at the end of that term, the court does not accept the plea of guilty or no contest and expunges the record, and it goes off, the record is sealed, and it is as though it never happened. Now, the rationale behind a deferred sentence is that these are extraordinary opportunities to give an individual that has never been in trouble before, that has got themselves in a situation that is not indicative of their character, and the court and the prosecution basically gives them another chance to come out of this situation without a criminal conviction. Now, the Sex Offender Act that you have before you and that we've discussed has in it a provision that says that judges and prosecutors cannot offer a deferred sentence to individuals charged with these litany of defenses. We need to know from the full committee whether you want the option of deferred sentencing or you don't want the option of deferred sentencing. So that's the question that's put forward. And Becky, would you want to add anything to that?
Well,
Without taking a side?
that's the hard part of it. I mean, I tried to come up with a list of pros and cons from the work group and then also from other people that I've discussed this with. And I think Todd presented the judicial and prosecutorial discretion really well. Some of the examples that were provided were if your evidence you're not sure that your evidence is good enough to convict somebody, that you could offer a deferred sentence and place the person on probation in hopes that you at least have something issued against the person where they at least have to conduct themselves in a certain way for so much time. The opposite argument of that is if you didn't have very good evidence, why did you charge the person? You could also exercise prosecutorial discretion by charging a lesser offense than one of these sexual offenses. You could also enter a plea with the a plea agreement with the person to, instead of charging them for sexual battery or rape, for simple battery. So there are other ways to exercise that discretion. The reason that I've included that in this law so that you will know where it came from is it's what Oklahoma requires. And so one of the arguments for keeping it in the code is that we don't want to have our citizens on our Indian country protected any less than the citizens who are on fee land in Oklahoma. So that's where that came from. That's what it's in there for. It's clearly a policy decision for the council to make.
Diane, would you want to add anything to that? I think that's silence as well. So that is the question, and based on that question, we have, as you can see, a couple of others. But it is up to the wisdom and the will of the council on how you direct us.
Ms. Watts and then Ms. Fishingham.
Thank you, Madam Chair. And just to clarify, something that you said, Mr. Hembry indicated that if we voted to have absolute sentencing, or not allow deferred sentencing, that, I guess, let me see if I can restate this. Whatever you said indicated to me that if we supported not having deferred sentencing, that would not allow the prosecution and the judge to have any ability to be flexible, but that's not what I understand, and that's not what I heard from Ms. Johnson. So there's other ways to deal with the same issue if they support not having deferred sentences.
Well,
yours sounded absolute, that if once they were charged and it was a sexual case, that they were absolutely going to have mandatory sentencing.
And I would stand by that statement. I mean, the way the law is right now, if you're charged with an offense under the sex offender, or these litany of offenses, the prosecution. They can
charge you with a lesser.
Oh, they can do it. Yeah, well, I'm saying if you're charged with one of these.
So there's another way out. Rather than deferred sentence.
Yeah, if you're convicted, But my statement is, if you are convicted of one of these,
then right.
Correct. The prosecution could not offer, nor the judge could not take a deferred sentence. Okay, now that is absolute. Okay, so yeah, there's any number of ways, that I mean, but what they could, the DA could not charge that offense. They could charge a lesser offense. The district court judge could not bind over at preliminary hearing. I mean, there's any number of deals here. I'm just saying, if you come to a conviction or a plea of guilty.
So, Madam Chair, my motion is to require mandatory sentencing for sex crimes as listed on this sheet.
I have a second.
That's actually
It's a separate question.
Moved and seconded, now we're open for discussion. Mr. Henry, continue.
There, actually, Councilor Watts's motion, it would be for the second part
Question.
of this. I guess what we need is the decennial decision by this council of whether you want to offer a deferred sentence, okay? Now, if the answer is yes, is there going to be mandatory sentencing? If the answer is no, we don't want to offer, well, then we go forward from there. So that's an appropriate motion for the next question, but I
Well, I
guess...
assumed when I said mandatory sentence that it would not allow for deferred
Okay,
sentencing.
well, then I think that would be the appropriate motion, and the second would adopt it. The motion would be that no deferred sentencing be offered in convictions or plea of guilty in these offenses listed.
Listed crimes here. All lines clear? Okay, we're in discussion. Ms. Fishinghoff.
I defer to Lori Jordan, since she's the head of that committee.
Ms. Jordan?
Todd, when we were in the work committee group for the last, I think the last meetings, I believe that was when Chief Smith came and visited with us. My understanding from talking with Chief Smith, who is a former prosecutor, as I am a former prosecutor, is that he was in favor of keeping a deferred sentence as an option for both the prosecutor and the judge. Was that your understanding?
That was my understanding at the meeting, and also I contacted Secretary of State Melanie Knight to actually confirm that position. She's not here, but she did confirm that that the chief was in favor of having the option of deferred sentencing.
And I believe that's in keeping with the idea that he nominates and we confirm very experienced district court judges who should have an array of options for any charge. For this reason, not everybody we can't take everyone and fit them into the same identical situation. You normally don't treat a habitual offender the same way you treat a one-time offense. You also have to be concerned about, on these type of charges, you have a lot of minors that are being asked to testify, some at a very, very young age, which actually the traumatizing is having to testify. So many prosecutors and judges prefer to see the option of a deferred sentence so that testimony will never have to take place. If the case is somewhat weak, or you have the testimony of a minor that at best credibility will be the subject of attack, sometimes the prosecution will want to give a deferred sentence. Then on a very minor offense, even one of a traffic violation, they have violated the deferred sentence. You can go back to the original period of time on the original charge, and that's what they can be placed in jail for without ever having to prove the original case. It is certainly an option that we are to think about leaving to the discretion of our experienced prosecutors and our experienced judges. And it's one of the few times, I guess you all probably are aware, that I agree with the chief on this. In fact, I told him that day, I said, I can't believe it, but we're actually agreeing on this subject. But I think it comes from both of us having had a former prosecutor background. So I would hope that you all would consider leaving the option of a deferred sentence on the table so that each case that comes before the court can be reviewed as to how harsh the three types of sentences need to be in that particular case. Thank you.
Thank you, Ms. Jordan. Mr. Hoskins?
Thank you, Madam Speaker. I couldn't agree more with Councilor Jordan. I think anything we can do to add a degree of discretion to the process on the side of the prosecutor and the judge is good. It will serve the system Well, I disagree, Ms. Johnson, with what I perceive to be a characterization of the issue as this. Mandatory sentences makes people safer. I just disagree with that. I think you may have characterized it as, are our people going to be less safe than the people in the state of Oklahoma because the state of Oklahoma has mandatory sentences without the discretion of deferred sentences? I guess I just disagree with the notion that underlies that. I think that jurisdictions, states, municipalities get into a race to see who can be the toughest on crime. It feels good, it looks good, it makes a wonderful press release, and sometimes it makes rotten criminal justice. And I think that we don't want to invite that kind of rottenness in our criminal justice system. I think competent judges, competent prosecutors, which we're blessed to have here in Cherokee Nation, can handle this discretion that we give them with the necessary prudence to make the system work. So I think we ought to do ourselves a favor, allow an additional bit of discretion to the judge and the prosecutor, and we'll be better served, and so will the people. Thank you, Madam Speaker.
Thank you. Dr. Cobb?
I am one that would probably be characterized as pretty tough on criminals, and I don't want my next statements to waver from that stance, but I do want to throw something out. In one of the many evenings past midnight when I couldn't sleep and the television was on, I actually was watching a program. It was in the state of Texas. Guy was 18 and a half, was dating a 15-year-old. They go to prom. The next morning, big blow up at the gal's house, and they had sex. So she gets mad, the mother gets mad, the mother of the daughter gets mad, goes down to the police station and says, this guy's raped my daughter. So they go pick this guy up, he's 18. He said, well, yeah, I mean, we're dating. Guy's charged as a sex offender, okay? It's on his record. She, in the meantime, over the course of the next couple of years, the girl graduates from high school. They get married. They have been married for 13 years. They have 3 daughters, and he is registered as a sex offender in the state of Texas. And every time he goes to get a job for a job interview, anything, it's listed as a sex offender. And he's married for 13 years with 3 daughters to the gal that he was charged with. So my point to that is I don't know the answer of how you limit that kind of problem, but anything we can do to limit something like that happening, I'm in favor of. I mean, I'm not an attorney, but there's got to be a way to, I mean, you know, if it's on there, and essentially the state of Texas response is there's nothing we can do about it. So, just want to throw that out.
Ms. Hammonds, did you have a comment?
I did. I just want the body to be clear that that's not the position of the Attorney General's office. That I believe I said at the work group, it was embarrassing to me personally for our deferred sentencing law to be more lenient than the state of Oklahoma. I realized by taking that position, one, I'm not in accord with the chief's views on it, and two, I'm taking away some of my own discretion. But I really feel that we ought to not be more lenient than our sister jurisdiction. I think that there are, once the decision has been made, what charge to file. And if our office believes that the situation is correct where we need to file one of these covered charges, then I fully support that is not the type of case where we will give a deferred sentence. If you do not pass this, and we do that, and there's a trial or there's a sentencing, and the judge, against our advice, decides to give a deferred sentence, then there can be a sexual predator out there who's never going to have a conviction. It may be a slight, I don't mean it that way to the judiciary, but I really think that by following in accord with other jurisdictions, that we just take a tough stance on these type of crimes and say these are the category of crimes that we are not going to give a deferred sentence to. Our discretion is still at the front end of what to charge. So That's our position. Certainly, legally is up to the discretion of the body which way to go. Thank you. As to I think we'll answer that in a few minutes.
Okay.
Mr. Baker?
Yeah, and I'm really struggling with this. I mean, we sit there and say we want to be not more lenient than our sister, yada, yada, yada. But folks, the bottom line here is the most heinous one of sexual abuse of a child. We can take them to court, we can do everything, but they're only going to get 1 year. That's it. That is a slap on the hand. I am sorry, but that's it. The state of Oklahoma can put them away for years, and we do not have that ability. I mean, I'd almost just not have one so that they have to go to the state, because if they do it, then I think they ought to pay for it. And we can go through this all we want, but folks, if we take it, it probably ends up being time served. By the time, they go to jail and goes through the court, it's going to take a year. And they'll spend the year in county jail, and that'll be it. And if it was in a state jurisdiction, they might go for 20 years in jail, or federal jurisdiction, even better. Because the federal jurisdiction is even tougher than the state. So, I'm really struggling with this, and it's not that I'm easy on crime, or I don't want to protect our kids and our families and all that, but we have limitations here, and I'm truly afraid that if we do this, then the federal prosecutor every time is going to say, "You've got your own laws, you take care of it." And Sharon, I'll yield to Sharon, but she did.
And I'm speaking off the cuff, so I may not be as articulate as I should be. As far as, I do believe there shouldn't be a deferred sentence, and even if we have...
Shouldn't or should?
Should not.
Okay.
Even if we have a limited sentencing, a year, 3 years, if a bit like the law says, they're going to. Even if we have that, we have concurrent jurisdiction with the feds. If it meets the federal criteria and we have concurrent jurisdiction, we can at least have them in that facility for a year until, if it's that bad, that it meets federal criteria, so that the feds can also give them. So we have concurrent, it's not one or the other, and it wouldn't go to state if it was on Indian country.
Right.
So we have that concurrent jurisdiction. As far as safety, and I believe what was meant here, and I haven't talked with her directly, but when you defer and then they're out, and I have an issue with, I guess I'm a lot more harsh than other people, and I think I've gotten that way because I see people getting out of jail all the time for something I think they should have been sentenced for, or sentenced more harshly than they were, and they commit the same crimes over and over. When you defer that, whether or not you catch them every time, they have the ability to go back out and harm another child or another person while you're seeing if they're going to be a good guy. I deferred it. Let's see if you're going to be a good person, good gal, or good guy. And they go out and do the same act. So the safety issue there is, you put them in jail, they're not going to go out and commit that crime on the same person or another person, because you're seeing if they're going to be a good person this time. So I don't like the deferred. I would prefer it not be there. But when you're talking the year, hopefully you meet the federal standard, but we can still get them in a facility while we're waiting for that federal case to go forward. Or if the feds don't give them as much time as we want, and you do it on every count, we get them in. Even when they get released from the federal court, we can put them back into tribal sentencing. So, you do have some options there. I think the option should be creative in how you sentence, not say deferred, but creative in how you sentence.
Mr. Baker, you should have the floor.
Well, now Todd's are shaking, so I'll give it to Todd.
Thanks, Todd.
All right. I'm going to speak as a Cherokee citizen and as an attorney. Okay?
The voice of reason.
The voice of reason. The one absolute in the law is that there are no absolutes. There is an exception for every situation. That's why, as was stated earlier, we have prosecutorial discretion as to what to charge and what to offer as a plea offer. That's why we have judicial discretion on whether to take the district attorney's suggestion or to find a person not guilty or reduce charges. With all due respect to district attorneys, they can be overzealous. Present company excluded. They can overcharge. And in many instances, especially in our tribal courts, defendants don't always have the resources to mount a spirited defense. They might get charged with, say, for example, engaging in sexual communications with a minor. Let's say we have an overzealous prosecutor who charges the person with that. Let's say from South Greasy, who doesn't have the resources to mount a spirited defense. He pleads guilty or she pleads guilty because she or he made some off-color comment to a minor. That person is going to have to register for it as a sex offender under this act for a minimum of 15 years, if not longer. There should be discretion with the district attorney. The district attorney doesn't have to offer deferred sentences. This district attorney will, this attorney general won't. And that's within her discretion. But the next one might want to. The judges that are appointed and confirmed by this council are done so because of their legal expertise and experiences, and we should trust that discretion, and we should not limit it. Like I said, the only absolute in the law is that there are no absolutes. And as an attorney, as a Cherokee citizen, I think it's better to err on the side of discretion than not.
Todd, not down to what Sharon said, I just, on a practical standpoint, if we really took somebody to task in tribal court on one of these, do you really think that the feds would step in and stack it, and that if they did it, we could come back and stack on them?
I'll let her answer that. What I know about the feds is that if it meets their criteria, they're taking the case. They're going to take the case.
Particularly on any sexual offense involving a child. And yes, we could, and yes, we do. The truth is, most of these cases do go federal. It's going to be an unusual case that would stay with the tribe. And that unusual case, I think, I don't want us to be a haven for sex offenders by being more lenient than our sister jurisdiction. That's just I'm seldom a right-wing prosecutor, but in this instance, that's how I feel. I don't think that we should be more lenient. I think that there are some level of offenses where deferred sentences are not proper, and I believe that this list includes those.
So, in practicality, you really don't think you'll see anything?
Not very often. No, we don't.
They'll still get to go to bed where they'll really get a sentence. I mean, that is my major concern, is that we take it and all of a sudden we give them 1 year and the feds or the federal judge says, hey, you got your courts, you've got your...
No. And I didn't mean to interrupt you, Mr. Baker, but it's not changing the substance of the law. I mean, we have all these crimes now. And that doesn't happen. The U.S. Attorney doesn't say, well, you could prosecute it in tribal court unless there's something wrong with the case and there's some reason they don't. And those are really the exceptions. We have all these substantively as crimes. That's not changed. We're not changing the law in that regard. What we are saying is, for these crimes that we have, you cannot give a deferred sentence.
I just don't want to give the feds now.
Understood and agreed, but I don't think that's should be a concern here.
Ms. Council, Mr. Soap, you haven't spoke yet.
What, do we have an idea of the number of cases that we might be increasing here through, some type of loophole, or we've obviously got these laws that are in effect right now. We're trying to maybe tighten them up a little bit and introduce different penalties, as the discussion is about. So what, in your experience, and you guys have got a lot of experience, are we talking 1 to 2 cases a month? Are we talking 20 cases a month? What's the,
I don't remember, Ms. Johnson, Mr. Morton, have we had one of these cases in tribal court in the last few years? I don't remember.
The last one I remember was in 2004.
Okay, so we're talking that maybe on average 1 case or 2 cases a year would be something that would really be outstanding, and it could be something that the federal government says, we're maxed out on all our judges, so you guys just need to, if you're going to see some type of justice at all within a given period, you need to take this case and do something, otherwise we're not going to address it in any time frame.
We've had one that we remember in the last 4 years.
Okay.
We have been very successful in federal court. If it meets their criteria at the base level and can work it in, they have taken our sex crimes cases because it's a major crime, and so they take our cases. The only time that, we have concurrent jurisdiction. You should always have the option to say, okay, this was a heinous crime. Feds gave him 15 years, and we hated it so much, we're going to give him this extra year, which is all we have right now. If they change the law, we'll have 3, but we'll give him an extra year on the end of that. Or we have not quite met that base criteria for the feds, and then it would fall into tribal court, because anytime we can't get it in the feds, it will come to tribal. We've been very lucky to have very good investigators, and they've got it to the federal level.
So my next question would be that we're stating that our judges have a lot of experience, and they have had this, ability to look at these cases and make decisions. But is that in fact the case? If we're only, if our bench is presumably maybe only considered 1 case in the last 6 years, then are they really that experienced, in your opinion? I mean,
the 2 lawyers themselves are experienced because they've been attorneys a long time and they've been in private practice, and I know that they've had those sorts of cases. Both of them also sit as judges in other jurisdictions. They're municipal jurisdictions, so they wouldn't be seeing felonies. I don't know how much experience they have with serious sexual criminal offenses. I would suspect that they have quite a bit because they're experienced lawyers.
One would assume that, but as far as going back to actual cases and saying this guy's had 4, the Cherokee Nation, we just don't have that much experience. It's kind of what I'm hearing.
That's right. We don't prosecute very many of them in the Cherokee Nation because they do go federally.
Mr. Henry, did you have a comment?
One comment I would make is, and based on the comments that were previously made, if it meets the base criteria, it's going to go federal, i.e. the heinous, easy cases go federal, and they get prosecuted and they get sent away for, because usually the federal cases they have a 98% conviction rate, and they're going to get convicted. So the most heinous, easy cases go federal. The questionable cases may stay tribal, which, in my opinion, would be all the more reason you would want to have some discretion, because these are not going to be clear-cut cases. That's the one point I want to make.
Ms. Fishing Hawk?
If we didn't have this code, would all of them go federal?
No. We still have these crimes on the book. We're not putting these crimes on the book. All we are doing is changing our sentencing procedure for these crimes. We still have them. Nothing's going to change in that regard.
But if we didn't have a code for these crimes, they would all go federal.
Some of them would probably just, if we didn't have a criminal justice system, probably some of them would go unprosecuted.
Ms. Calhoun? Thank you, Madam Chair.
There's a couple of things. I think young love is technically been addressed, but Becky can talk to that in more detail. And there's concern for that. And that's another question we also need to vote on in the actual logistics of the age. Another thing that's been talked about, but I want to make sure it's clear in everyone's mind, that the laws themselves, the 3 acts, any reference to the terms of sentencing that would be under the Indian Civil Rights Act have been changed to reference that law because it's being proposed on the Hill in D.C. to change that and expand it from 1 year maximum to 3 years, for example, and other items of interest. So it no longer references those specifics and limits us to it, but it more references that act at the federal level, which would allow us to immediately increase without having to amend these acts again. And so that's addressed as well. I've been assured by the U.S. Attorney's Office when I talked to them and spoke with them personally that these would continue to be prosecuted, that this wouldn't, just because we're updating our code to include like computer crimes around child pornography and other things, that's not something that they're just going to immediately abandon us in some form or fashion. But I think I really dug deep to understand where other people were coming from on this issue. I understand that some of you have prosecuted these cases personally as lawyers or been on the defense side as lawyers. As a tribal citizen, I take these kind of crimes very personally. And I talk to people who have been raped, who've been molested, and I do not think, when I talk to them, I'm sorry, these are very personal. And I do not agree with the idea that we do not mandate these crimes. And potentially in our community, as small as it is, allow people to make deals which might make them defer. To me, these acts are worse than even murder. And I think it's that personal, whether that's a stranger who attacks someone, our children, people my age, elders. I think that it would behoove us not to create a thing where, when we have spotted jurisdiction, allow somebody that is the type of person that would cause harm in a sexual way to another individual, the ability to cross the street in knowing that we have lesser we're going to prosecute them less. So let's go rape the Indian child next door who sits on trust land. And I think that's what we create when we do not, at least, at minimum, create the same standards as the state in mandatory sentencing without deferred sentences. And so I personally won't understand if this body decides to allow deferred sentences on these crimes. But as a member of this body, I know that we do not want to devolve any jurisdiction to the state of Oklahoma. And so we need to move forward with the Adam Walsh Act and the requirements and the criminal code updating that needs to go with that in the September rules meeting and the October council meeting, regardless of the outcome of this vote today. But again, I just don't personally understand. I've dug deep and talked to several people who, though they may not be lawyers, they're not prosecutors, they're not judges, they don't understand why we would not set minimum sentencing and required sentencing. Thank you, Madam Chair.
Mr. Thornton, you haven't spoken yet.
Yes, I've got a question. Maybe I don't really understand all of this, but if we have a crime and a person's convicted, and as a criminal of this nature, if it's federal or state, if he's a criminal and he's convicted, does he come back and go on Cherokee Nation's book as a convicted sex criminal, or is he just going to the state and the federal areas and go on their business? If we've got a person that commits this crime in the state, in other words, is Cherokee, does it have to be, in other words, does this have to be trust land before these people can go on our booking as being a criminal?
Well, no, I mean, we still have access to those records, and what the sex offender registry does is provide all of law enforcement all those records, and by stepping up as a government and signing on to sex offender registration, we include our criminals, for want of a better term, the ones that live, work, or student on Indian country. But the only crimes that we have jurisdiction over, that the tribe has jurisdiction over, are crimes committed by Indians on Indian country.
But it looks like we would still have the responsibility of our people in Indian country knowing that these people were sex offenders.
We do.
We do. If this act passes, let's say someone who is a sex offender in Enid and comes to California, he or she is going to have the responsibility to notify both the state of Oklahoma and the Cherokee Nation that they plan on staying here for more than 5 days and therefore need to register as a sex offender. However, that topic this topic is best set for the September rules meeting. It's really not germane to the deferred sentencing part, that we're discussing right now. But to answer your question, that if they move into or move out of the Cherokee Nation, we're going to have to be notified.
Are they convicted inside the Cherokee Nation?
Do
we have a booking of any kind that we can put these people down on? Or do we? Or is it just left up to, we have to pull the state's bookings?
Yes, sir. The Sex Offender Registration Act that will be put in front of this committee, the finalized one, it will be available on the website just like the state is currently, and it will be anyone, for instance, if we convict someone or if the federal government convicts somebody who committed a crime on Indian country, we will be the jurisdiction that registers them initially. If they commit the crime elsewhere and move into, go to school here or work here in our Indian country, then we will also register them for that. And that will all feed into one big federal database.
Well, in the past, and I know this wouldn't more or less be changing the subject, but in Sequoyah County, I've seen people charged and their lawyers go to trial and their lawyers are so powerful that they don't even have to show up and the charges drop. And I would hate to see that happen on the sex crime offenses. And that's one reason that I probably would vote for this. Because I've taken people to jail, charged them with a crime, and then they just be dismissed. And I know that they committed a crime, wasn't on ice, but there's things that happen that way that shouldn't be happening, and I think this right here probably will help. Thank you.
Mr. Hoskin?
I withdraw.
Dr. Cobb? Ms. Jordan?
Well, I guess I'll probably be the last one that talks.
No, Chris Stowe.
Okay, well, I'll go ahead and talk anyway. Unless Chris wants my time. I realize emotions run high on this issue, and nothing we do here today, and no matter how much of a sentence you give an individual, the victim is never going to be made whole again. I mean, it just doesn't work that way in the criminal system. I had a daughter that's no longer with us, and if this had happened to her, I'm certain my emotions would run very high. I have granddaughters now, and if this happens to them, I'm certain my emotions are going to run very high. But as a counselor, I think I have to look at the entire picture. And I truly believe Diane may have made my best case for leaving a deferred sentence, because she said, as a prosecutor, it would be used on a very, very limited basis. But it needs to be there for that one case that maybe it's appropriate for. I do disagree with Diane in that I have faith in our judges, and that's why we have prosecutors, judges, and defense attorneys. So everyone can give a total picture to that particular case. If that judge sees something, sees a crack there that may be heavy counseling coupled with a deferred sentence, will make that person a rehabilitated citizen and a good citizen for the future. We need that option there. If you don't have deferred sentencing, if you take out the discretion for prosecutors and judges, then I believe you have a flawed system. You have a system that's working totally 100% against the people. We're fitting everybody, we're saying everybody's a square peg, and we're going to crush them into a round hole. Now, folks, we know that's not true. We know that there are kids that will be caught up in this system as offenders, that given a second opportunity, they may become very productive citizens of this country, possibly even become some of our higher officials. With a deferred sentence, that option is still there. With a suspended sentence or with mandatory sentencing, that option is no longer with us. I do not agree that we have to abide with what the state of Oklahoma does. I've worked under the state of Oklahoma's system. I truly believe this body can create a better system, a system that is more comparable and usable for our people. We are our own nation. We do not have to copy our next door neighbor. We shouldn't even be trying to copy our next door neighbor. We should be building our system for our people. And I would just ask you to take that into consideration when you make this vote. The motion on the floor is to not allow a deferred sentence in any case. That's any case. It will no longer be there. And to have mandatory sentencing. I would ask you to vote that down. Let's leave that deferred sentence there to the discretion of the judges. And by the way, I think someone did ask about the judges' experience. I know both of those judges. They have been former prosecutors. They have been defense attorneys. They are judges in other jurisdictions. We passed them through this committee to make them judges. If we see a person coming through this committee that lacks the capacity to make these decisions, folks, stop them here each and every time. The most important thing we can do is confirm our judges. If we are just getting someone that happens to be a friend of a friend, folks, send them back home. This is our option. We can keep the most experienced judges in the world on the bench, and we will keep good prosecutors and good law enforcement like we have right back here, and they will be very, very conservative in using the deferred sentence. But don't throw that option out for them. Leave that option for them. And for Diane, I'm going to help her despite herself. She needs that total discretion. I would ask you respectfully to look at the entire picture, vote this motion down. Let's leave this deferred sentence on the table for these experienced prosecutors and judges and law enforcement to consider. Thank you.
Mr. Fulbright and then Mr. Soap will finalize it.
Well, I'm really tough on crime, and I have a 23-year-old daughter, and I would hate to think what I would do, or my husband if somebody did something to her. But I cannot be for this mandatory sentencing because I know a fine gentleman that is 50 years old that got in the most terrible situation, never had committed a crime of any kind that we know of. He married a lady, was married to her for many years. He was a very good stepfather. And his wife ran off with another woman. And they moved down into Sequoia County and they started dealing drugs. And he called me and said, could you check on them down at certain school? And I said yes, and their attendance and whatever. The kids weren't going to school or anything, and he reported them. And because they were dealing drugs, and he was generally concerned for his stepchildren. Okay, they wanted to get back at him. They got the 13-year-old girl to say that he had been molesting her all these years. And it drug on for quite a while. It went to court. And I read in the paper, you know, he pled guilty to, and he received a deferred sentence. And I said, why on earth did he do that? And it was because the 13-year-old is now 15, and she's pregnant. And the attorney said when she gets out and on her own, away from her mother, she might recant her story later on. And if this goes to a jury trial, you're looking at time in prison, because she can be a very convincing child that convince them that you did this to her and it's your word against hers. And he went ahead and pled guilty, and he got home, he has to stay at home for so long and whatever, you know. And he got a deferred sentence. And here's a man who I think, in my judgment, deserved a deferred sentence. I think he was falsely accused as a vendetta against getting back at him for reporting them for doing drugs, and they were very, very bitter. And I do not want to see the judges say they have to have a mandatory sentence, because there's always another side to the story.
Thank you, Mr. White. Mr. Soap and then Dr. Cobb, that's all.
Yes. This Attorney General, do you know if there's been any studies done where there's data that would suggest that has told jurors where mandatory sentencing has been involved on whether or not that affects their decision? It's one thing to say someone is guilty, but it's another for them to assume that decision-making process for an effect judgment on someone, to say that you're going to spend time in jail for a year. Is there any studies that you're aware of that impact the jurors' decision-making capabilities in that sense?
I'm sure there are. I don't know of anything to share with you as to whether if the juries know that a deferred sentence could not be given, if that would affect their determination.
Right. I mean, it's one thing to say, yeah, I think he's guilty, but it's so-and-so's job over here to determine how long he's going to spend in jail. But rather than I would rather be, make a wrong decision than to wrongly accuse somebody, and so the jurors start having this decision-making going on. And then I'm just saying, is there any state or case studies that might say that jurors tend to be light on crime in that case because they're not going to?
I don't know of any, and I hope that my assistant AGs will correct me in the back if I'm wrong, but I believe that in our jurisdiction, the jury itself imposes the sentence. So they might say, yes, you're guilty 6 months.
Okay, so
and the judge has the authority to determine whether or not you do that 6 months, to suspend that 6 months, or whether or not to defer.
Okay, so the jurors do have an initial say.
The jurors in our tribal court have sentencing. The judge cannot do deferred on a jury verdict under Title 22. Is that correct?
It's
Okay,
guilty.
that's what.
It's only for a guilty plea or a plea of no contest.
But not a jury verdict.
And not a jury verdict.
Okay. Sorry, that was a circuitous way to answer your question, but I hope we
So in any event, then if one of these cases do go to trial and it gets to see a jury, then there's no, it doesn't even matter. It's up to the people who hear the case, and it's not in the hands of somebody else. So in that sense, it would make it easy for a jury to know and not have to deliberate, well, should we give a guy 6 months or should we give a guy 9 months? It's just an automatic maximum 1 year or whatever mandatory sentencing is determined to be.
Correct.
Okay, thank you.
Dr. Cobb,
Thank you, Madam
final
Speaker.
answer.
I'm sorry. I just, not being an attorney, and with all due respect, being a doctor, I'm sure that trial lawyers and insurance company executives probably aren't on my short list of inviting to family functions. But I guess what I want to know is, and oh, heaven forbid this ever happened, but what if the justice system screws up? I mean, what if they get it wrong? I guess my question is, what are the, I don't know. What are the options? What if 5, 10, 15 years down the road, somebody says, oh, well, you know what? We kind of screwed this up. I mean, I mean,
The option in that case was not to have charged it. I think there is an option that if somebody's registered, that they can be taken off by judicial order. Is that correct?
I'm not sure if I understand the question, actually. You mean if we say you can have a deferred sentence, but...
yeah, what if, okay, Councilor Fulbright, what if the guy had not pled guilty so he could get a deferred sentence? What if he stood up, you know, and he was a passionate individual and said, you know what, I didn't do this. And by God, if you're going to put me in jail for 20 years, you just go ahead and do it, because I did not do it. And what if this girl comes up 5 years later and says, okay, look, I was 13, I was coerced. I mean, what happens?
If it's from a jury trial, they can file a motion to reopen it, but the judge doesn't have to do that either. So
It's a motion for new trial for newly discovered evidence if you have a recantation.
Right. And that happens. Yeah, I mean, you know, these stories you see on E! Network or whatever, I mean, they do happen. That's why it's important throughout the judicial system is to have a system of checks and balances.
I guess that's what I'm asking.
Yeah, I mean,
that's what I want to know.
Yeah, you have a system of checks and balances. You may have a overzealous district attorney or a too lenient district attorney. Let's say the district attorney overcharges the offense. Well, that's why you have the preliminary hearing system for a judge, a neutral magistrate, to come in and judge to see, well, did you meet the core of these offense? Then, you know, if it does, it goes to trial, and then you have the checks and balances of a jury of your peers, whether to find it guilty or not guilty. And even above that, you have at the trial level, you have the judge saying, well, you know, after the district attorney has put on their evidence, there's not a jury that could render a guilty verdict, so we are taking that case away from the jury. You know, you know, in all cases, in this case, you know, that let's say we have an individual, for whatever reason, whether it's lack of resources or it's a lack to put someone through it, sometimes no contest means no contest. I don't want to go through this. I don't want to put my family through it. I don't want to put any person, through this. I plead no contest. You'd have a discretion of a judge to say, well, looking at this evidence in totality concerning the pre-sentencing report, I'm going to give you a deferred sentence. Yeah, that's why all the way through the checks and that's why I'm in favor of deferred sentences, because it allows for more checks and balances in the judicial system. There are no absolutes. There are no hard line decisions. Every case, it needs to be decided upon the merits and the facts of that case, and that's and the most heinous need to have the hardest penalties, and the closest cases, and depending a litany of factors, a suspended or deferred sentence might be the most appropriate.
If I may, you just answered exactly why. I want to know exactly why you're not in favor of deferred sentences. And I know you said it, but I want you to say it again.
Two reasons. One I previously said, and one I didn't say. Sex offenses, notoriously, you can ask the marshal, you can ask any social worker, sex offenders are the worst recidivists. Most of those folks in that arena will tell you they cannot be cured. We're not talking about assault and battery, we're not talking about DUI. We are talking about a sex offense involving a child. I feel very strongly about those. I am as ultra-conservative a prosecutor as you can find on those types of crimes. And everybody knows I'm not really a conservative prosecutor usually. The second thing is, if we allow deferred sentences for these crimes, we are more lenient than our sister jurisdiction in the state of Oklahoma, and that's embarrassing to me as a prosecutor. I don't want us to be more lenient on sex offenses than another jurisdiction. I don't think that these guys are smart enough to say, If I fondle a kid on this side of the highway, I can get a deferred sentence, but if I do it over there, I can't. But I don't want that even to be in the realm of possibility. Okay, that's why.
Call for question.
Question's been called. The motion is, to make sure I have this straight here, to require mandatory sentences on sex crimes with no deferred sentencing.
Yes, Madam Chair.
Okay,
So a yes means you are for mandatory, and a no means you are not for
that's
mandatory.
correct. Yes is you're for mandatory, no, you are not for mandatory.
Just to make it clear,
Okay.
a vote yes means that you do not want to allow deferred sentences. Mandatory sentencing is really a separate issue. A vote yes means that there will be no deferred sentences also. A vote no says that there will be deferred sentences also.
Yes means there will be deferred sentencing. No means there will not be deferred sentencing, correct?
All minds clear. A yes vote means, a yes vote means that there will not be deferred sentences offered. A no vote means that there will be deferred sentences offered.
Roll call, Madam Chair.
Roll call.
Julia Coates?
No.
Bradley Cobb?
Yes.
Joe Crittenden?
Yes.
Jody Fishinghop?
Pass, go ahead.
Meredith Fraley?
No.
Janelle Fulbright?
No.
Don Garvin?
Yes.
Chuck Hoskin Jr.?
No.
Tina Glory Jordan? No. Curtis Snell?
Yes.
Chris Soap?
Yes.
David Thornton?
Yes.
Kara Cowan Watts?
Yes.
Bill England?
Yes.
Bill John Baker?
Yes.
Jack Baker?
Yes.
Harley Buzzard?
Yes.
Jody Fishinghop?
Yes.
We have 12 yes and 5 no.
12 yes and 5 no. Motion carries. Okay, very good discussion. Okay, now you will take that information and tweak the legislation, correct, Todd?
A couple other questions that we need guidance from, and they kind of would fall in the same line. Should individuals be charged with the following crimes be permitted to receive a deferred sentence? Okay, we have determined that answer is no. And so question 1A, if the answer to question number 1 is yes, should those offenders still be required as sex offenders? So that's not applicable anymore. B, if the answer to question number 1 is no, which it is, should those offenders be required to serve some amount of time in jail, i.e. should there be mandatory jail time, which means that there would be, if a person's convicted, and they're going to be registered as a sex offender, and they're going to have, that should it be mandated by the judge or a jury that they serve some portion of that time in jail. That was the question that needs guidance on.
Thank you, Madam Chair. I move that we support mandatory jail time for offenders with those crimes.
Second.
Moved in second. Discussion? Any discussion? All in favor signify by saying aye.
Aye.
All opposed, same sign.
No.
No.
Roll call. Yes means you support mandatory jail time.
Don Garvin?
Yes.
Chuck Hoskin Jr.?
No.
Tina Glory Jordan? No. Curtis Snell?
Yes.
Chris Soap?
Yes.
David Thornton?
Yes.
Kara Cowan Watts?
Yes.
Bill England?
Yes.
Bill John Baker?
Yes.
Jack Baker?
Yes.
Harley Buzzard?
Yes.
Julia Coates?
No.
Bradley Cobb?
Yes.
Joe Crittenden?
Yes.
Jody Fishinghop?
No.
Meredith Fraley,
No.
Janelle Fulbright.
No.
11 yes and 6 no.
11 yes, 6 no, motion carries.
Now, the last question that the working group needs guidance on is, at what age should a person be able to consent to sexual activity? Should the person be able to consent to sexual to activity with another person of any age, or to someone within a certain range of ages? I.e., what we're looking for is either a bright line age, such as 16, 18, or is there a range that if I'm 16, I can consent to someone 2 years either way, i.e. consent to someone 14 or to 18, or any variation thereof? That's what we're needing.
What does Todd, what's the state law say?
State law is 16. Age of consent is 16, unless you're a school, you're in a teacher-student relationship or some type of counselor type
Right,
deal.
if a child is in someone's care, for instance, teachers, social workers, those types of things, if you're in a trust position to the person, then they're deemed to not be able to consent to you even if they're 16.
You'd have to be over 18. Well, you'd have to be out of that care.
Right.
Yeah.
Right.
You have to be out of that care. So, the state is a bright line age of 16. Some states have the +2, -2, and actually, are we amending for the school thing?
Yes, we don't
Yeah.
have that right now.
Okay, but that is on the table. Yeah.
For some reason, I've read that law, I'm getting 15 for some reason.
Sharon, did you have a comment?
But in federal is also 16.
I just keep inching in there, don't I? Well, I'm wondering about whether or not to make it similar to the federal law, which is like if you're at the age of 14, it's 2 years. But if it's like the age of 16, 4 years difference, then you're okay. And I can't remember all of the laws, but they have a whole age variance. So like if you had someone 14 with another child, you're not going to see so much as a crime as some other type of issue. 16, you can go as low as 14, and say it's consensual. If you have an adult who is 18 or more, you can only go so far down, and I'd have to research those. But if you touch something like that, you're not penalizing someone saying, used to the state code was under the age of 16, it was automatically a rape type thing. So if you looked at the federal law, which is what we do our sex crimes based on to get them in the federal criteria, when you're looking at a child, it gives part of what you addressed. If there's an 18-year-old and a 15-year-old, well, if there's not more than 4 years difference between that 18-year-old, you're okay. Because at that age, but when you reach 21, it's not okay. They have that in the federal code, so that I think because of those very issues that has come up in court before, and those laws have been adopted. So I'd say at least give a look at that code when you look at those, because it does give some leeways.
I would make a motion that we adopt the federal codes in that situation.
Second motion.
Ms. Cameron?
And I think that the way it's currently written, it is reflective of federal code, so I was going to put that on the table as a starting point. So you have to be at least 16 years of age to be able to consent to sex, period. So a 16-year-old is not licensed.
What is it? The federal 14, as young as, you definitely would be a crime 12 and under. 14, if you're within a certain age limit of someone, you would be consensual. But if you were 14 and it was 18-year-old.
Okay, well, I looked at it differently, I guess. So this is the way I structured it. So you would have to be at least, in my mind, how you looked at it is you'd have to be at least 16 years old to be
old enough to be able to consent to having sex with anyone. So once you turn 16, the way it's in the act right now, then you could consent to sex, but you could only consent to sex with somebody that was your age up to 2 years older. So if it was a 16-year-old, it'd be an 18-year-old, and if it was a 17-year-old, it would be a 19-year-old. Once you're 18, you're an adult. So that's the way it's structured in the act right now, regardless of what federal or state or anything else says. I think that's where we need to decide what's acceptable and what we want in our community. I don't know how reflective of that is of the federal code. Thank you, Madam Chair.
Dr. Cobb?
All I'm concerned about on this part of the discussion is, let's think about how many seniors are dating sophomores, and if you want to push that down to a freshman, you are looking at 14. So when you're having this discussion, I mean, how many seniors are dating sophomores? Because you're looking at some of the sophomores being 15, and you also need a lot of the high schools are 4-year high schools. You're looking at freshmen dating a senior. So you're definitely going to be that 18 to 15 range. I mean, 18 to 14 range. So I just want to throw that out while we're having this discussion, that if you limit that to 15, and you've got a senior dating a freshman, and you've got a problem. And if you limit to 16, you got a senior dating a sophomore, you got a problem. So just want to throw that out.
Ms. Coates?
Yeah, and I think, to me, this goes along the same sort of reasoning as the deferred sentencing, is that you have to take not every 17-year-old is the same as every other 17-year-old, and not every 14-year-old is the same as every other 14-year-old, and we are talking about criminalizing teenage relationships, and this is one area to be really, really careful, it seems to me, on something like this. And I think that, I'm sorry the body did not see fit to give our judges leeway on the previous point, I accept that, but I really hope on this one that we would be very careful before we make criminals out of kids who are in some first relationship without experience.
Comment?
To address that, I think that what Ms. Wright explained about the federal law would make it would make our laws deal more effectively with what you're bringing up. Because right now, just to make it clear, it is a crime at 16 if the person's under 16, no matter how much the other person is. So if it's a 15-year-old and a 16-year-old, the 16-year-old, under our current statute, is committing a crime because the 15-year-old is deemed not to be able to consent. So those issues that Mr. Cobb raised, right now, those are criminal. The federal law is written the way it is to take that into account. And it's similar to what is in the Act right now. It doesn't address the 14 and 13-year-old relationships, but that could be added in easily to deal with that.
Mr. Becker?
Call for the question on adopting the federal code.
Question has been called. All in favor, signify by saying aye.
Aye.
All opposed, same sign.
No.
One no. Okay, motion carries. Are we finished now, Mr. Embry? Is there anything else you want to include on that?
Thank you. Yes, Madam Chairman, we are complete with this part of the discussion, and let me commend the committee for very thoughtful and respectful debate. This is a prime example of how the committee process works. Thank you very much.
Thank you. Item 2 is confirming the nomination of Imogen McCollum as a board member of the Comprehensive Care Agency. Ms. Handy, is Ms. McCollum here? I believe so.
Second.
Moved and seconded. All in favor, signify by saying aye. Aye. All opposed, same sign. You did good. Good. Item 3 is an amendment to the Constitution providing for the replacement of council member, the process for Mr. Baker.
Yes, Madam Chair. When the Constitution was written in '99, there was no provision for runoffs for multiple district areas. And in that case, if a district had 2 council people and there may be 10 people or more filed, then the top 2 vote getters would be the council people. And in the constitutional amendment, if something would happen to one of those, then the next higher one would get it, which made sense at the time. But with the runoff provision, I do not believe that it does, because I think someone who receives a minority of the vote could then become the council person. So I move that we amend the Constitution and strike the portion that says such seat shall be filled by the candidate having the next highest number of votes in that district, who is available and willing to serve and whose eligibility is confirmed by the election commission, in the event that no such candidate exists. Okay, we strike that, and then the balance of it says that the council shall fill the vacated seat in the following manner. If the majority of the 4-year term remains to be served, the council shall authorize a special election in the district of the vacated seat to be conducted within 90 days. If the minority of the 4-year term remains to be served, the council shall elect a replacement who would otherwise be qualified to serve in the district of the vacated seat. So I make a motion that we approve this
Second
constitutional
motion.
amendment.
Moved and seconded.
Madam Chair, just to clarify, this is going on the next regular election. We're not amending
Right.
the Constitution, we're just putting the amendment on the ballot. Okay, thank you.
Any further questions, discussion? All in favor, signify by saying aye.
Aye.
All opposed, same sign.
Aye.
Roll call. Yes, as you want to amend in accordance with Mr. Baker's recommendation.
David Thornton,
No.
Kara Fallon Watts,
Yes.
Bill Anglin,
Yes.
Bill John Baker,
No.
Jack Baker,
Yes.
Harley Buzzard,
Yes.
Julia Coates,
Yes.
Bradley Cobb,
Yes.
Joe Crittenden,
No.
Jody Fishinghawk,
No.
Meredith Fraley,
Yes.
Janelle Fulbright, yes, John Garvin,
Yes.
Chuck Hoskin Jr.,
Yes.
Tina Gloria Jordan,
No.
Curtis Snell,
Yes.
Chris Sutter.
Yes.
Twelve yes and 5 no.
12 yes, 5 no, motion carries. Okay, item number 4 is a limited waiver of sovereign immunity on branding opportunities. Mr. Stewart.
Good afternoon.
Afternoon.
Yeah.
I always wanted to be a lawyer, but somehow I got into numbers. I'm glad I took the side road. You all are be commended for all of your work there, but numbers always add up. That's the main thing. Sometimes the law doesn't. What we have is a request from C&E for the purpose of affecting its marketing strategies. The strategy is similar to those used when we brand with McGill's and more recently with Toby Keith when he came down and, we branded that Toby Keith I Love This Bar and Grill. Those brands have significant value and it's part of our strategy to tap into that. A couple of points about this waiver. It does not come into play without the approval of any agreement by our board of directors. And if you know about the work that we do as a management team and the board before they approve anything, there's a lot of work that goes in before there's any decision made, a lot of research done and so on. So we prove the value before we present it to the board. And this waiver would effectively allow us to look at other brands that we use at the hotel. So it's for your approval to place on the agenda if you so desire, and allow us to work with our board for any agreement that might fit the bill for that.
Ms. Calhoun Watts.
I'd like to move to approve.
Second.
Moved and seconded. Discussion. Mr. Stewart, I just have a couple of questions.
Okay.
If we pass this rather broad resolution. In number 1A, I,
Okay.
we're talking about a successor in interest.
Yes.
How is that defined?
Yeah, well, what happens is, if there's an owner of a particular brand, and then we do business with that owner, and then that owner would sell the brand, then really, since we've entered into the agreement with that owner, we have to give the owner a chance to sell it. So that's all the intent is for that. And I think that would be a normal and customary provision.
And one more,
Okay.
under small d, we have lost profits included in the be it resolved, the last be it resolved, but we don't have it there in D. Would that be significant or not? Since it's in the be it resolved.
Now say, where are we on little d in number one?
Yes,
Does not allow recovery, incidental or exemplary.
Incidental, punitive, or exemplary damages.
Yeah, again,
Or
so,
lost profits, we don't have it there, but we have it in the be it resolved. Is that significant?
and where is the be it resolved?
The very last sentence, paragraph. We have it there, but we
Well,
don't have it in
I'm
D.
looking for the be it resolved. Is that, down here? Well, yeah, I mean, as long as it's in the agreement, I think,
Under be it resolved. it's
yes,
there.
be it resolved is, I don't know why that's not in there, but as long as we have it in there, I think it's fine.
Mason, do you agree? You agree? If it's
Since it's
in
in
the
the
be it
agreement.
resolved, but it's not in small d.
Yeah,
Since it covers some of the same stuff, it might be easier to understand if it's placed back in to part 1A, C, and D. If it's added into there, it might make it much clearer.
Okay.
Okay, I'll tell you, I'll look into that and get back. I think we can do that, and we'll report back to Todd. What is your view about that? It's in the resolution here, but not stated here. Is that concerning or not?
Well, not overly so. What I would recommend is that if the council, if the committee is so inclined to pass it, that we go ahead and pass that, and then at the September full council, if there is a need to amend it on the floor there, we'll
Make
maybe have to do
that amendment based on his recommendation after we look at it. Is that?
It's not just mine.
Or your recommendation.
Any other questions,
All right.
comments? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Motion carries. And
Okay, thank you very
We
much.
will have a copy of any type of agreement to,
Absolutely. We will get a copy of that to Todd before we actually approve it.
And just for the edification of the committee as a whole, I have received a detailed agreement that is, what we described 90% complete, and the Attorney General's office has also received that agreement, and any counselor is welcome to look at that agreement, and it's not stand confidential, but we'll use discretion.
Okay, thank you.
thank you, Mr. Stewart. Any announcements? Entertain a motion to adjourn.
So moved.
Second.
Moved and second, all in favor, signify by saying aye.
Aye.
Opposed, same sign.
Next meeting?
Mr. Baker.
10 minutes.